My name is Vanessa Cole, and I have spent 19 years as a forensic accountant, which means I have spent 19 years being the person companies call when they suspect someone they trusted has been lying to them with numbers. I never once imagined that person would turn out to be my own brother, and I never once imagined I'd be the one standing in a Cook County courtroom, 34 pages bound in blue resting on the table in front of me, watching a judge's expression change on page 7 in real time. People sometimes ask me now whether 19 years of this work prepared me for that moment, and the honest answer is both yes and not at all. The professional part of me knew exactly what page 7 would do the instant Judge Okafor reached it, but nothing in 19 years of other people's fraud had prepared me for the specific vertigo of watching my own brother's face when it did. I should start with our father, because none of this makes sense without him. Harold Cole built Cultec Fabrication from a single leased warehouse in Cicero in 1979 into a genuinely substantial precision metal fabrication company, 90 employees at its peak, contracts with aerospace and automotive suppliers across the Midwest, the kind of business that made my father a modestly wealthy man by the time he was 60, though you'd never have known it from how he lived. Same house in Berwyn for 41 years, same truck for a decade past when he should have replaced it. A man who measured his own success, not in what he spent, but in what he'd built, and what he could still hand down intact. He used to walk the shop floor every morning before the day shift started, a habit he kept up almost until the end, greeting workers by name, checking machinery he technically no longer needed to check because he had managers for that, and I think that habit says more about who he actually was than any balance sheet could. A man who never fully separated the company from himself, who treated its employees' livelihoods as something closer to a personal obligation than a line item. My brother, Grant, for years older than me, went into the business straight out of college, the assumed successor, and spent 22 years there, working his way from the shop floor into operations management and eventually, in the last decade of our father's life, into the role of de facto general manager, running the company's daily operations while our father, increasingly limited by heart problems in his final years, stepped back from active oversight. I remember visiting the shop as a teenager and watching Grant work alongside our father, the two of them speaking a kind of shorthand about tolerances and vendor contracts that I never fully learned, and some part of me, even then, understood that Grant's whole identity was being built inside those walls in a way mine never would be, for better and, eventually, for much worse. I went a different direction. I got a degree in accounting, then a CPA license, then a specialization in forensic accounting almost by accident, after a professor in graduate school pulled me aside following a case study project and told me I had an unusual gift for spotting the specific kind of inconsistency that most people's eyes slide right past. I spent the first decade of my career at a Big Four firm's forensic services group, working cases that ranged from mundane vendor kickback schemes to a genuinely notorious municipal corruption investigation in my third year that made the local news for months and taught me, early, how much damage a trusted insider can do simply by understanding, better than anyone auditing them, exactly which numbers nobody bothers to double-check. I went independent 12 years ago, building a small but respected practice, Cole Forensic Advisory, that now handles complex fraud investigations and litigation support for mid-sized companies across Illinois and Indiana, 6 employees, a client roster built almost entirely on referral, work I'm genuinely proud of in the specific quiet way you're proud of something built slowly and honestly. My father was, in his own way, quietly proud of that career too, though he rarely said so directly. I found out, only after he died, going through his desk, that he'd kept a framed newspaper clipping from that municipal corruption case, the one with my name in it as part of the investigating team, tucked in a drawer rather than displayed, the way he kept most things he cared about but didn't know how to talk about openly. Finding that clipping is one of the few genuinely comforting memories I have from the weeks after his funeral. I want to explain something about Grant before I explain what he did, because I think it matters, and because making him a simple villain would be dishonest to what actually happened between us over 4 decades as siblings. Grant spent his entire adult life in our father's shadow in a way I never fully had to, because I'd left the family orbit early enough to build an identity separate from Cultec. Grant never got that separation. Every promotion he earned came filtered through the assumption that he was being groomed, not hired. Every decision he made at the company got quietly measured against what our father would have done, even in the years our father was too sick to be in the building most days. I think, watching this unfold over the past year and a half, that Grant spent 2 decades performing a version of confidence he didn't actually feel, running a company whose ultimate authority never fully transferred to him even as the daily responsibility did, and that the specific kind of resentment that builds in a person forced to carry authority without ever being granted full ownership of it can curdle slowly into something that starts to feel, from the inside, like entitlement rather than theft. Our father died 14 months ago, at 78, after a final decline that took about 6 weeks from diagnosis to the end. Fast enough that none of us had properly prepared, slow enough that we all had time to say most of what needed saying, except, I would later learn, for the things that actually mattered most. His will named Grant and me as equal beneficiaries of his estate, including a 50-50 split of his majority ownership stake in Caltech, with Grant continuing as general manager and me, per the will's explicit instruction, serving as an oversight trustee for the ownership trust for a 5-year transition period, a role our father had apparently added in an amendment about 18 months before he died. A role neither Grant nor I had discussed with each other beforehand, and one I suspect our father added quietly, without telling either of us, because some part of him had started noticing something he didn't yet have proof of and wanted a check in place regardless. I didn't understand, at the time, why he'd structured it that way. I do now. The trustee role required me to review Caltech's quarterly financials, a formality I expected to be exactly that, a formality, given 22 years of Grant running daily operations competently and our father's evident trust in him for most of that time. I pulled the first quarterly package about 4 months after the estate settled, mostly out of professional habit more than suspicion, the same instinct that makes me double-check a restaurant bill even when I'm confident it's correct. What I found, in a line item labeled Strategic Consulting, Meridian Advisory Group, a category that had grown from roughly $40,000 a year historically to just over $600,000 across the 18 months before our father's death, was the kind of discrepancy that, in any other engagement, I would have flagged within an hour and escalated by the end of the day. I didn't do that immediately with Grant. I want to be honest about that hesitation, because it's the part of this story that doesn't fit neatly into either villain or hero, and it's the part I've had to sit with the most. I called him instead, framed it as a routine question, asked what Meridian Advisory Group did for the company, and why the spend had grown so dramatically. He told me it was strategic planning support during our father's decline, a consultant he'd brought in to help stabilize operations during an uncertain leadership transition, a plausible explanation, delivered smoothly, and I remember wanting, badly, to believe it because the alternative was a version of my brother I didn't want to be true. I remember hanging up that call and sitting in my car in my own driveway for almost 20 minutes afterward, not ready to go inside, running through everything he'd said, trying to convince myself the explanation held together, aware, even as I tried, of the specific quality of my own doubt, the same quality I'd learned, professionally, over 19 years, to recognize as the leading edge of something I didn't want to find. It took me 3 more weeks, working quietly, using the professional tools I use for every other client, to find out that Meridian Advisory Group had no employees, no physical office, no verifiable client work product anywhere in Caltech's files beyond a handful of generic slide decks that appeared to have been assembled after the fact rather than delivered contemporaneously as billed. I remember the specific evening I found the shell entity's registration, sitting at my own kitchen table long after Marcus and Priya had gone to bed, running the same searches I'd run 100 times for other clients, Secretary of State filings, registered agent records, UCC lien searches, the unglamorous digital paper trail that almost always exists somewhere if you're patient enough to follow it, and feeling a very specific, very unwelcome dread building with each search result. The particular dread of a professional recognizing the pattern of a fraud before she's ready to accept who's on the other end of it. It had no verifiable business address beyond a mailbox rental service in Naperville, and its sole listed corporate officer, buried 3 layers down in Illinois Secretary of State filings under a holding entity structure that took real effort to unwind, was Grant's brother-in-law, our sister-in-law Denise's brother, a man named Roy Petrosky who had, as far as I could determine, no actual consulting background of any kind. I sat with that discovery for 2 full days before I did anything with it, the same kind of paralysis I imagine most people feel when the evidence in front of them points somewhere they desperately don't want it to point. I called an old colleague from my Big 4 years, a woman named Beatrice who'd become one of my closest professional confidants over the decades, not asking her to review the case, just needing to say the facts out loud to someone who understood exactly what they meant without needing them explained. She didn't tell me what to do. She just said, "You already know what you'd tell a client to do with this. The hard part isn't knowing. It's that this time the client is your brother." I've thought about that sentence more times than almost anything else anyone said to me during those 14 months. I brought what I'd found to Grant directly in person at his house, hoping, even then, for an explanation that would make it not what it looked like. He didn't offer one. He got angry instead, in a way I'd genuinely never seen from him before, told me I had no right to audit him like a criminal, told me our father had trusted him to run the company and that my little forensic hobby was an insult to 22 years of work, and somewhere in that conversation, I understood that the anger wasn't really about my having found something. It was about being seen, finally, by the one person in the family whose judgment he'd apparently decided, at some point, didn't count enough to worry about. I brought my findings to the other trust beneficiaries. Our father had also left smaller trust shares to Grant's 2 adult children and my own daughter, structured that way specifically to keep future ownership spread across the next generation, and recommended, formally, in my capacity as trustee, an independent forensic audit of Colteca's finances going back 3 years. Grant hired an attorney within a week of that recommendation, a well-resourced litigator named Whitfield Marsh, and filed suit against me, not against the audit recommendation directly, but a broader civil complaint alleging that I had breached my fiduciary duty as trustee by conducting an unauthorized and defamatory investigation outside the proper scope of my role, seeking my removal as trustee and monetary damages for what the complaint characterized as reputational harm to both him and Coltec. I hired my own attorney, a careful, precise woman named Odalise Ferreira who specializes in trust and fiduciary litigation, and told her everything, including my own uncertainty about whether I'd handled the initial weeks correctly, whether calling Grant directly before escalating had been a mistake that had given him time to prepare a defense rather than simply confirming what I'd already found. She told me something I've held on to since. You're allowed to have hoped he had an explanation. Hoping for the best in your brother isn't a procedural failure. It's just what siblings do, right up until they can't anymore. I want to explain the actual audit because it's the center of everything that happened in that courtroom. Odalise retained an independent forensic accounting firm out of respect for conflict of interest concerns. Even though I'm qualified to have done the work myself, she wanted the findings to come from someone with zero personal stake, someone Whitfield Marsh couldn't attack on grounds of bias. The firm she chose, led by a meticulous senior partner named Desmond Achebe, who I'd worked alongside years earlier at my old Big 4 firm, spent 4 months reconstructing the full financial trail behind Meridian Advisory Group, tracing not just the $600,000 in consulting fees, but a second, more troubling pattern Desmond's team found almost by accident while pulling bank records. A series of 11 wire transfers, totaling just under $2.1 million across 3 years, routed from Colteca's operating account through Meridian to a secondary holding account controlled by Roy Petrosky, then onward, in smaller increments, into accounts that traced back, through several more layers, to Grant himself. Desmond's report ran 34 pages, bound in blue, the 7th of which contained the wire transfer schedule laid out in a simple table: dates, amounts, routing numbers, account holder names, the kind of unglamorous, devastating clarity that only comes from someone who has spent decades learning exactly how to make numbers impossible to argue with. The hearing was in the Daily Center downtown, a modern courtroom with the particular fluorescent flatness of a building built for volume rather than gravity. Grant arrived with Whitfield Marsh and 2 associates, an unusually large legal team for what was, on paper, a trust dispute, and I understood, watching them set up at the plaintiff's table, that Grant had spent an enormous amount of money. I'd later learn, through discovery, that his legal spend had reached $340,000 by that point, on the specific hope of overwhelming the proceeding before anyone looked closely at the underlying facts. I sat with Odalise at our own table, Considerably smaller, no associates flanking me, just the two of us and the blue-bound report sitting squarely between us. And I remember thinking, watching Grant's team arrange their materials with practiced theatrical confidence, that they'd clearly built their entire strategy around volume and intimidation rather than substance. A strategy that works remarkably often in civil litigation, Odalise had told me, right up until it encounters a single piece of paper it can't argue around. Grant smiled at me once, early on, a small, confident smile that I recognized from childhood. The same smile he used to give me right before he was about to win an argument he'd carefully rigged in advance. The time he'd swapped price tags on our shared Christmas gifts to make his look cheaper so our parents wouldn't feel he'd gotten more. The debate tournament in high school where he'd memorized his opponent's entire strategy from a mutual friend beforehand. Small, clever manipulations I'd spent decades reading as harmless competitiveness rather than what I now understand as an early, recognizable pattern. Something in me went very still and very calm seeing that same smile in a courtroom because I understood, finally, exactly what kind of certainty I was up against and exactly how long it had actually been building. The defendant has no standing, no evidence, and no case, Whitfield Marsh announced, dropping a thick brief on his own table for emphasis, a theatrical gesture that landed, I thought, slightly too hard in a room with fluorescent lighting and a visibly unimpressed court reporter. He spent close to 15 minutes laying out his argument, characterizing my trustee investigation as an unauthorized overreach, citing the specific trust language that defined my oversight role narrowly, arguing that I had exceeded that scope by commissioning an independent audit without board approval, a technically sophisticated argument that I understood, listening to it, was designed to make the case about procedure rather than substance, to keep the judge's attention on the boundaries of my authority rather than on what my investigation had actually found. Your Honor, we move for immediate dismissal. The judge, a deliberate, unhurried man named Okafor, looked at me. I nodded to Odalise, who stood, walked calmly to the bench, and handed over the report. Your Honor, we ask that you read page 7 before ruling. The courtroom waited. I watched Judge Okafor turn the pages methodically, without hurry, the specific unhurried pace of a man who has learned, over many years on the bench, not to let a room's tension dictate his reading speed. I could hear, in that silence, the particular ambient sounds of a courtroom holding its breath, the shuffle of Whitfield Marsh's associate adjusting papers, the faint hum of the fluorescent lights overhead, Grant's own breathing audible enough, 2 seats away, that I found myself, absurdly, counting it. He reached page 7. I watched his expression change. Not dramatically, nothing you'd catch on camera from across a room, just a small, precise tightening around his eyes, the look of a man doing arithmetic he didn't expect to need to do that morning. He looked up, first at Whitfield Marsh, then longer at Grant. Counsel, he said, are you aware of the contents of this exhibit? Whitfield Marsh, to his credit, didn't bluff. He asked for a recess to review the document with his client, and Judge Okafor granted it, but not before adding, in a tone that had gone from unhurried to unmistakably serious, I'll note for the record that page 7 of this report documents what appears to be a pattern of wire transfers consistent with embezzlement from a company's operating accounts, routed through a shell entity to the plaintiff, Mr. Cole, personally. Given the amounts and pattern involved, the court has an independent obligation to refer this matter to federal authorities regardless of how the civil claims here are resolved. I watched Grant's face when the judge said the word federal. Whatever composure he'd walked in with simply left him. All at once, the specific collapse of a man who has spent 18 months telling himself a story sturdy enough to survive a lawsuit but never actually tested against a judge's independent legal obligations. Whitfield Marsh, beside him, had gone very quiet, the particular quiet of an attorney recalculating not just his case, but his own professional exposure for having filed it without apparently reviewing his own client's underlying finances closely enough. I noticed, in that 15-minute recess that followed, that Grant didn't look at me even once, staring instead at a fixed point on the defense table, and I understood, watching him, that whatever version of this confrontation he'd rehearsed in his head over the preceding months, it hadn't included this particular ending. The civil case didn't survive that hearing in any meaningful form. Grant's complaint against me was withdrawn within 2 weeks, and separately, as Judge Okafor had indicated, the court's referral triggered a federal investigation that, as of this year, has resulted in Grant being indicted on 3 counts of wire fraud and 1 count of embezzlement from an employee benefit plan, a case that is, as I write this, still working its way through the federal docket, with Grant out on bond and facing, if convicted, a sentence his own criminal attorney has apparently told him could run into several years. I didn't feel triumphant watching any of it. I want to be honest about that, the same honesty I owe every part of the story. I felt, mostly, a specific, heavy grief that had been building for months and finally had nowhere left to hide once page 7 landed. Grief for the version of my brother I'd spent my whole life believing existed underneath whatever tension had built between us. Grief for my father, who I now understand had likely suspected something in his final year and built a trustee structure specifically to protect the company from a truth he didn't live long enough to fully confirm, and grief, strangest of all, for Roy Petrosky, Grant's brother-in-law, a man I'd met maybe a dozen times at family gatherings over the years, who has also now been charged, and who I understand, from Denise, is barely speaking to Grant anymore, having apparently believed, by his own account to investigators, that the arrangement was some legitimate, if unconventional consulting relationship rather than the laundering vehicle it turned out to be. That's the cost underneath the resolution, the part that doesn't fit into a clean verdict. I have not spoken to Grant since the day of the hearing. His children, my niece and nephew, have been distant with me since the indictment, not hostile exactly, just careful, the particular caution of young adults who don't yet know how to hold both truths at once, that their father did something genuinely wrong, and that their aunt is the reason the world found out. My niece, Ashley, sent me a single text message a few weeks after the indictment, just 3 words, "I still love you," with nothing else attached, no explanation, no follow-up when I responded, and I've held on to that message more than almost anything else from this entire year, a small, fragile thread across a distance neither of us has figured out how to close yet. My sister-in-law Denise called me once, a few weeks after the indictment, and the conversation was brief and difficult, her voice thick with an anger I understood and didn't try to argue with, though she also said, near the end of the call, something I've turned over many times since. "I know you didn't do this to him. He did this to himself. I just don't know how to be around you and not think about it." I told her I understood, and I did, and we haven't spoken since. Caltech itself has survived, remarkably, under an interim management team I helped install as trustee, with the 90 remaining employees keeping their jobs, the aerospace and automotive contracts intact, my father's actual life's work continuing forward even as the family who built it around him came apart. I visited the shop floor myself, once, about 2 months after the hearing, something I hadn't done in years, and stood for a while near the same machinery my father used to walk past every morning, watching workers I didn't recognize going about ordinary shifts, entirely unaware or unconcerned with whatever had happened in a downtown courtroom, and I found something quietly steadying in that ordinariness, in the fact that the actual work of the place had continued regardless of what the people who owned it had done to each other. I take some real comfort in that, more than I expected to, that whatever else was lost, the thing my father spent 40 years building didn't have to die alongside his trust in the son he'd handed it to. The rest of my life kept moving through all 14 months of this, the way it apparently always does. My daughter, Priya, started her sophomore year at Northwestern the same month the lawsuit was filed, studying environmental engineering, largely oblivious to the worst of what was happening in her extended family, because I made a deliberate choice to shield her from the daily details. A choice I've since had to partially reverse now that the indictment has made local news, and she's had to field questions from classmates who somehow know more about her family than she'd like. She called me the week the indictment story broke, upset in a way I hadn't seen from her since she was much younger. Not at me, exactly, but at the general unfairness of having to explain, to relative strangers, a family situation she'd had almost no say in, and even less warning about. I drove up to Evanston that weekend, sat with her in her dorm's common room, and we talked for 2 hours about things that had nothing to do with Caltech or courtrooms, her coursework, a boy she'd started seeing, a research project on watershed contamination she was genuinely excited about, and I left that evening grateful in a way I don't think I could have articulated before this year. 4. How much of a person's actual life exists entirely outside whatever crisis happens to be consuming? The loudest part of it. My husband, Marcus, a structural engineer who has weathered 14 months of late-night calls with Odalise and stacks of financial exhibits spread across our dining room table with a patience I don't know that I could have matched in his position, took over most of the household logistics during the worst stretches. The quiet, unglamorous partnership that never once made it into any court filing, but held the actual structure of my life together, while the visible part of it came apart in public. Marcus has his own complicated history with his own brother, a decades-long estrangement over an inheritance dispute from his mother's side of the family that predates our marriage, and I think that shared, unspoken understanding of what it costs to lose a sibling relationship over money, even when you're technically in the right, has made him a steadier presence through this than almost anyone else in my life, because he's never once tried to tell me how I should feel about any of it. My business, Cole Forensic Advisory, kept operating the entire time. I brought on a new senior associate, a sharp young CPA named Talia Nguyen, specifically to cover client work during the months I was most consumed by my own case, and found, watching her handle 2 complex engagements independently for the first time, a genuine professional pride that had nothing to do with anything happening in a courtroom. Talia has, in the months since, become something closer to a protege than an employee, asking me the kind of sharp, curious questions about methodology that remind me why I loved this work before it became personal, and I've started deliberately mentoring her the way Beatrice mentored me decades ago, a small continuity I've come to find genuinely meaningful against the backdrop of everything else falling apart. I've also started over the past several months, going back to something I'd let go of for years, long-distance running, something I did seriously in my 20s before Priya was born, and let quietly lapse under the accumulated weight of building a business and raising a family. I ran my first half marathon in over a decade 3 months ago, a decision that had nothing to do with fitness and everything to do with needing one part of my week where the only numbers that mattered were pace splits, not wire transfer amounts. My training partner, a neighbor named Odette who has absolutely no connection to any of this and has never once asked me a follow-up question about the case beyond a kind, general, "How are you holding up?" has become one of the steadiest relationships in my life this past year, precisely because it exists entirely outside the wreckage. We run most mornings before either of our households wakes up, mostly in silence, and I've come to treasure that silence more than almost any conversation I've had this year, a small, physical, uncomplicated hour that belongs to nobody's case file. I think about my father sometimes, and the quiet trustee clause he added 18 months before he died, never explaining it to either of us, and I've come to believe it was the last real thing he did for this family. Not the company, not the money, but a small, unglamorous safeguard built out of a suspicion he never got to confirm himself, trusting that if something was actually wrong, I'd be the one to find it. I asked Odalise once, fairly late in the process, whether she thought our father could have known, even partially, what Grant was doing, and she told me she couldn't speculate on that professionally, but that in her experience, clauses like the one our father added rarely appear in a will by accident. Someone usually notices something, even if they can't yet name it, and builds a door for the truth to walk through later, when they're no longer around to walk through it themselves. I don't know if that's true of my father specifically. I want it to be true because it would mean his last significant act toward both of his children wasn't blind trust in one and none at all in the other, but something more careful, more protective, aimed at preserving what he'd built regardless of which of us turned out to have earned that protection. I don't know if that trust feels like a gift or a burden most days. I think it's probably both, the way most of the truest inheritances are. I don't know what happens to Grant now in any final sense. The federal case is still moving through discovery. His attorneys have filed several motions I've only heard about secondhand through Odalise, and I've made a deliberate choice not to follow the proceedings closely, both because I've done my part already and because there's a version of watching that would start to feel less like accountability and more like something I don't want to become. I think about him sometimes anyway, not the version from that courtroom, composure collapsing on page 7, but an earlier version, Grant at 9 or 10, showing me how to ride a bike in the alley behind our childhood house, patient in a way he rarely got credit for being, before either of us had any idea what the next 4 decades would eventually cost us both. Page 7 of that report sits in a drawer in my office now, the same drawer where I keep a handful of other case files I never fully close in my mind, and I think about it sometimes, late at night, the exact moment Judge Okafor's expression changed, the specific silence of a full courtroom watching a man's composure disappear in real time. I don't feel proud of that moment, exactly. I feel something closer to the specific, hollow relief of a job I never wanted finished correctly, and a family that will never again be what I spent 40 years assuming, without ever quite examining it, that it still was.